I salute you all. Thanks for being on and thanks for watching. Thanks for being always subscribe the videos and like or comment. And in any case where you feel that a certain point is not clear, feel free to comment, to put your question in the comment section so that we can tackle it exhaustively and we appreciate the law. Today we are going to look at the law of contract basically. And the law of contract, basically, we are going to look at its preamble. What is it all about? The elements, basically. And what you have to know about law of contract. Law of contract is one of the easiest course units. Basically, here we are dealing with something that we practice in the day-to-day events. Most of our life, however much live along the legal perspective, but our lives lives on contract law. Basically, any agreement that we do, that is a contract, basically. However much we do it without knowing, but the essence here is that it is a contract that we have carried out. So as you are reading, or as you are revising, or you are trying to understand this course unit, you relate it to the day-to-day events, dealings, so that we can appreciate what contract law is all about, basically. Now, today we are going to look at contract. Its preamble pattern, one of the elements of a valid contract. And a contract can be defined as an agreement between two people. That is the English definition. But legally, a contract is defined under Section 2 of the Contract Act, Cap 284 or 2010, as an agreement enforceable by law according to Section 10. And Section 10 of the Contract Act stipulates that a contract is it is an agreement, or it is something that has been created from free consent or free will, with willful consideration and with the intention to make it legally binding. That is the legal definition of a contract, basically. And when you look at the contract law, it has certain categories. We have the first category, we have contracts by deed and simple contracts. Contracts by deed, these are contracts that are signed, witnessed, attested, that are signed with witnesses around. That is a contract by deed. Then we have a simple contract. For a simple contract is like the opposite of a contract by deed. This is just carried out. It can be carried out orally, you understand, without being witnessed, without being signed, but it is also a category of contract. Then also we have bilateral and unilateral. Bilateral and unilateral contracts. Bilateral, these are contracts made out of exchange of promises. For them, they are exchange of promises. That's what we mean by bilateral. It is just a means of exchange of promises. Whereas unilateral, it is an exchange of a promise for an act. Actually, what do they mean under bilateral? What do they mean by exchange of promises? Basically, here you promise the buyer to upon delivery, then the buyer also promises to deliver. That is a contract, exchange of promise. Then unilateral, which is exchange of promise by act. Here it's that you have done, someone tells you to do an act, then after he pays you. That is a unilateral contract. Basically, not that in mind or bear that in mind. So that is some of the things that we can talk about, the introductory part of the contract. But however, we have the vitiating factors, the elements of a valid contract. What makes a contract valid? What makes a contract binding? Those are the questions. You get. Realize that we have like 4 elements of a valid contract. We have offer, acceptance, consideration, and intention. You get. Realized, but these elements are too vital. Once one misses, then the contract is not is not binding. And today we shall look at one of them as the elements of of a valid contract. And today we shall look at an offer. What do we mean by an offer? Basically, not in mind that an offer is one of the elements of a valid contract. Any contract must have an offer at the face of it for it to be binding. An offer is like a promise made by one person to be bound on certain terms. You understand? An offer is like a request. You understand? You are giving in so that someone can accept what you are giving in. You get? And an offer, basically they say that it must be certain and it must not be vague. What do they mean by certain and not vague? It must have what are you offering? It must be certain. What are you offering? You get? So that someone can accept something with full information. You get? There's a good case there, Gibson versus Manchester City Council. It is a good case about there. And here, an example, if someone says that I want to sell chairs of fair quality, you understand? Then the offeree and the offerer are well acquainted with the information. You understand? Then it makes it an offer that is valid. Remember, an offer can be made to an individual, it can be made to a group of persons, and it can be made to the entire world, as we shall see the case of Khalil versus Carbolic Smoke Ball Company. It can also made to be to the entire world. Get? So basically, note that in mind, or bear that in what? In mind. So as we move further, realize that an offer, basically it must not be an invitation to treat or an invitation to offer. You get? So basically, what you have to bear in mind that an offer has some of the silent features. You get? Whereby there must be willingness to do or abstain. It must be made to another person, and it must be made with the view of obtaining consent or asset from another person. But however, we have rules that governs a valid offer. You get? However much these rules they are governed for an offer to be valid. First of all, an offer may be express or implied. What do they mean by express or implied? Express, it must be seen visibly. You accept that it is yes. Implied, basically here, your act can act as an offer. Your act. You get? Basically here they say that a person making an offer may be bound if in his words or his act. You get? So that to induce someone to accept. You get? Secondly, an offer must contain certainty of expression. You understand? What do they mean, certainty of expression? Here, basically, they say that courts won't accept or will not accept an agreement being a contract unless it can be shown that the offer to all the material terms and the contracts is agreed. You get? So put that in mind. And an offer can be made to the world at large, and it can be accepted by anybody who performs the necessary actions. Here I relate to the case of Khalil versus Carbolic Smoke Ball Company. Here an offer was made to the entire world. Understand? But however, they were claiming that it was an invitation to treat, of which court held that it was what? It was an offer. Here I realized that under Khalil, this Carbolic Smoke Company made certain drug and say that whoever will use this drug and gets influenza will be compensated. Khalil used the medicine in the prescription that were subscribed, but however he got influenza. So he sued the company. You understand? He sued the what? The company. But however, the company was saying that it was an invitation to treat, not an offer. But however, court held that anyone that followed the prescription that was made by Carbolic Smoke Company was entitled to the damages that were put by the company. So put that in mind, that an offer can also be made to the entire world, to entire world. Whoever fulfills the conditions of the offer, he makes it a valid what? Offer. Or his acceptance becomes valid to that particular what? Offer. So note that in mind. Another thing what you have to note that an offer must give rise to legal consequences, or it must have the intention to create what? A legal relations. You understand? What do they mean that it must have the intention? The good example is like this. If I promise my girlfriend to take her out, I say I want to take you out, and the girlfriend accepts the offer. If I fail to take the girlfriend, my girlfriend cannot sue me, because the offer was not, the intention wasn't to create what? Legal consequences or legal relations. He cannot take me to court for damages for breach of a contract, because my intention of the offer wasn't to create legal what? Relations. But a valid offer must create legal obligations. And also, for an offer to be valid, it must be communicated to the offeree. What do they mean that to the offeree? if you make an offer, it must be communicated to the offeree. Here in this instance, what they are trying to mean is that for someone cannot be binding by someone's offer once it wasn't communicated to him or her. Basically, basically here what you have to bear in mind is that the communication of an offer must be from the offerer to the offeree. So the good example is like this about communication of an offer. Here I'll give a scenario whereby it is me, I've lost my child, and I put in the newspaper that whoever finds my child, there is a reward of 200,000 Ugandan shillings. But there comes the one Alvin. Alvin finds the what? The child. But however, he didn't see the advert that I put on TV or newspaper, and he takes the child to the nearest police station without knowing the reward. Then after, the one Alvin realizes that there was a prize for whoever found the child. But however, when he goes back to claim, he cannot claim. Reason being, the offer didn't reach onto him so that he can accept. He didn't accept the offer. You get? So he couldn't claim for what? For that money. That's where we come with the point that the offer must be communicated to the offeree. You cannot do something then realize after doing. You get? So bear that in mind, or note that. So basically, note that in mind. Then when you go further, we have the revocation of an offer. When you read section 5, section 5, subsection 1 of the Contracts Act provides that an offer can be revoked at any time once there has not been communication of acceptance. So it can be revoked at any time once there is no what? Communication, effective communication of acceptance or of the offerer. Relate to the case of Brian versus Van Timhoven. That is a good case. Then we have the modes of revocation of an offer stipulated in section 6 of the Contracts Act. One of it that the communication of revocation by the offerer himself, by the offerer to the offeree, to the other party before acceptance, say lapse of time. If the offer was for the week, if the week lapses, then the offer doesn't exist anymore. Then there is failure of the acceptor to fulfill the conditions of the what? Of the offer. Then there is also death, or once the offerer dies or becomes insane. Once the offerer dies or becomes insane, automatically the offer is revoked, or where the fact of death of insanity comes on the side of the what? Of the acceptor before acceptance, the offer can also be revoked. So basically that's what I can talk about an offer, basically.